Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hi, I'm Kim Gray, and welcome to the Men's Divorce Podcast. I'm here today with Ashley Ward. Ashley, why don't you go ahead and introduce yourself?
Sure. My name is Ashley Ward. I am a lead litigator in the Baltimore, Maryland office.
Awesome. So I'm Kim Gray. I am a managing partner. I am in the Town and Country office. I've been practicing for about 20 years and been with Cordell for 15. Want to remind everybody that if you want to schedule a consultation, then call 1-866-DADS-LAW or visit CordellCordell.com to schedule your consultation. We've got in-person consultations. We've got phone, Zoom, whatever fits your schedule. We are here for you. So go ahead and reach out if you would like a consult. Today, we are going to be talking about discovery. Discovery is a really important topic when it comes to family law because that is how we get all of the information. So Ashley is going to talk to us a lot about that. So first, Ashley, why don't we get started and you tell me a little bit about discovery in the legal practice?
Sure. I think discovery on top of litigation is one of the most important toolboxes that we have in preparation for a case. It's literally how we get information. You know, when people watch TV and they're being surprised about some sort of witness or some sort of piece of paper for trial, that's really fiction. During the trial preparation, we are getting lots of information from the other party. We're asking different questions under oath. We're getting copious amounts of documents, either from the party or from our own work. And that's what helps us to really dig deep and determine what's important for the case and what evidence we'll be able to use either to support our case or to defend our case in terms of what's being presented. So it is tantamount to a well-prepared case.
So what are some of the types of discovery that we use in family law?
Sure. So the types of discovery that we use is similar to all types of law. It's just more so about the questions that we ask. So the two most common discovery tools that we use are what's called interrogatories and requests for production of documents. Interrogatories are actually questions, and every state's different, but at least in Maryland, we are allowed to ask up to 30 questions that the party has to respond to under oath. This is great because it's under oath and can be used against them if they aren't truthful when it comes to trial. These questions can range for something as simple as explaining their job to as detailed as their bank account information. Once they provide that, there also is what's called the request for production of documents. It's exactly what it sounds like. We are requesting different documents for them to produce. And we can go back as far as necessary, notwithstanding any type of objection. Typically for myself, I'll ask for 5 to 10 years worth of documents. We're talking about tax returns, pay stubs, leases, insurance, retirement accounts, different documents that we can look at to determine what's important for the case. Now, those are the two different discovery documents that we give to opposing parties. But the next typical discovery tool that we use is called subpoenas. Subpoena duces tecum specifically, where we will subpoena different institutions to receive documents under the threat of them having to come in for either testimony or deposition. And so typically we will subpoena banks to get more records that maybe the opposing party can't provide us. We will subpoena jobs. In custody cases, we'll subpoena schools for school records. Phone companies to get phone records and things of that sort. Really, it's the sky's the limit. If there's some sort of institution that holds some form of documentation, generally we can subpoena them to get that documents. Those are the three most typical tools that we use.
So we get all of these documents, we get all these questions answered. What happens if we go through all the documents and we've got lots of questions? Because obviously that's a whole lot of information. And a lot of times getting more information just leads to more questions and more things that you want to find information about. So when you get that, and after the attorney has gone through everything, what's the next step? What other options do you have to do some more digging or to ask more questions after you have received all of those documents?
Sure. Well, it's twofold, right? So when we get our discovery production from opposing party, we look through it, we make sure we take our notes, and we also determine whether or not it's deficient or not. So if they provide us with documents, but maybe they're missing years or missing certain information, we can request that they correct that deficiency to ensure that we have complete discovery. But a lot of times, like you said, we still have questions that maybe a document in itself can't answer. In those situations, we can then do what's called a deposition. A deposition is where we actually have a party or a witness come in and we will ask them questions under oath. I actually like to call it trial training or trial practice because you're essentially doing a list of questions in regards to what you have seen to try and get more information so that you're not surprised at trial in terms of a document that might lead to some sort of a question. But it's very important because with that deposition, you actually create a transcript. And that transcript, much like the answers to interrogatories, is going to be under oath and can be used at trial if they change their answers in regards to whatever is being produced for evidence.
Who are you allowed to depose in a family law case?
You're allowed to depose anyone within the case, so the plaintiff and the defendant, but also witnesses that either have been called by the other party or not. And sometimes maybe they're not witnesses, but they're tantamount to the case. So maybe they might become witnesses at some point, and so you certainly can call them. Now, if they're not represented or they're not an actual party to this case, they certainly can obtain their own attorneys, and sometimes there's even objections to depositions. But if you can show the court that whatever you're seeking is important to your case, generally the court is pretty flexible in who you're allowed to depose.
Do you always take depositions in every case?
Absolutely not. Specifically for me, I am very judicious with my depositions because one, they can be very expensive. Like I said, they're a little mini trial in themselves. And sometimes you can get enough information from your discovery alone. But it's important that if you do not understand or there's something that you're missing, you never want to ask a question for the first time without knowing the answer at trial. If you find that deposition is going to give you that information, then it's definitely going to help in regards to having a better understanding of what you're presenting. But they're not always required, especially if it's a cost prohibitive process.
Okay. So I want to go back to interrogatories. So you mentioned that you're allowed to ask questions. You said in your state you're limited to 30. I know in other states you can do a lot more, and sometimes it even varies by county. So for example, in Missouri, in certain counties, you have to do the standard 30 or 32, and then in other counties it's unlimited. So those questions that you're talking about, are they, when you're saying you're limited to 30, are they a standard 30, or do you get to create your own questions? How does that work?
Great question. So, there are definitely, especially in our state, there are standard questions that you can ask, and you even provide kind of a copy and paste from general questions, but the best interrogatories are the ones that are specific to the issues. So there are always going to be some basic ones in regards to your job or your if it's a divorce in terms of property. There's going to be some general questions you always ask, but a lot of times you can ask questions pursuant to the facts of the case. If there's an allegation made in a complaint for divorce or complaint for custody, you can ask for them to provide details in regards to the allegation. So you have an idea of what evidence they intend to present in order to support the allegation that they made before the court. The more specific the interrogatory, the better prepared you're going to be for the trial.
So my favorite kind of discovery is request for admissions. I think those are a lot of fun. Can you tell us a little bit about the request for admissions?
They are probably my favorite too. I don't use them as much as I used to, but they are so fun because whereas interrogatories are asking a very specific question that gives you kind of an ability to expand upon your answer, and production of documents is just giving you a document and saying whether or not you have it or not. Request for admissions is where you're going to be asking them a series of facts, whether they're true or not, but a series of statements in which the person has to either admit, deny, admit with some sort of explanation, or deny with some sort of explanation. And it's really great because, again, very much like the answers to interrogatories are under oath. And essentially, it kind of allows you to, one, distill what the actual facts are, so you can have a lot of ways that you don't have to worry about asking those questions later. But also, what most people don't realize is discovery has a time frame in which you have to produce all of those documents or answer those interrogatories. And if you don't, certainly you can go to court, request certain sanctions, or ask the court to help you encourage the person to produce the discovery. But admissions of facts, there really is a little bit less of flexibility with that. At least in Maryland, you have 30 days to answer those admissions. And if you do not provide your signed admissions to facts, whatever is placed in those admissions is automatically assumed to be fact. So you can be very, very unique in your questions in the sense that you can put things in there that maybe aren't necessarily true but would help your case. And if the person is not paying attention and not providing the proper admissions in a timely fashion, that is helping your case. And there really is a hard way to get around that because the rules are very clear, at least in Maryland.
Yeah, and I agree. It's the same in Missouri. And I think it's also a really good reason why it's important to get a family law attorney who's experienced in practicing in these matters. Because when I was practicing and having cases, one of the biggest things was if you did those requests for admissions and you had someone who didn't standardly practice family law, or they were just doing a case for someone, or it wasn't their normal area of practice, they would often miss that request for admission deadline, and we would be able to have those questions deemed admitted. So that's one of the reasons it's one of my favorite forms of discovery.
It's very helpful.
Yeah, it is very helpful. When you have a case, how do you determine like your discovery strategy? So you get a new file, you read the facts, the petition. Take us through kind of how you decide what you're going to do discovery-wise on the case.
Sure. Discovery strategy begins immediately upon, meeting with your client, especially that follow-up meeting after they have retained and reviewing whatever pleadings have already been filed. That is the most important time to really determine the kind of route you're going to take with discovery. Some of the questions I ask are, what schools do your children attend? What banks do you and your spouse bank at? What jobs do you have? And so what are the issues in the case? And so that from there I can kind of decide, okay, my questions are going to be based solely more on financials or more on personal aspects. We really need to figure out witnesses, or we need to figure out what our experts are going to be. And then discovery is a continuing obligation. So upon getting documents, I find a lot of times bank accounts, once we get documents from them, that will encourage further discovery process. So maybe we'll discover a hidden bank account or a credit card account or some other business that we weren't aware of that wasn't presented, and that will lead to either additional questions or subpoenas. So initially we kind of have an idea, and then we branch out based off of what we receive. But the first meeting, we are deciding from there what's going to be the most important aspect to get to, and then we continue to grow as time goes on and get more information from there.
Awesome. So we're talking a lot about doing discovery and getting information from the other side, but obviously they have the opportunity to ask us questions as well, and for our client to have to respond. So tell me a little bit about your strategies on our responses for our clients.
Yeah, I think people don't always take discovery that seriously. And when I say people, I mean more so the clients. They think it's just kind of a long, tedious process, so they just want it to be over, but it's extremely important. We try to make it as easy as possible for our clients to complete. So usually when we get our documents from opposing counsel or discovery requests, they're usually in a PDF or a hard copy. We will ask them to give us a electronic Word copy so that the parties are able to actually type directly onto a computer as opposed to having to write them down and transpose them. Most discoveries due within 30 days. I cut that in half to ensure that I have an opportunity to review everything that's being produced. We want to make sure that, my client and myself are aware what's being produced. The worst thing that ever can happen is you go to trial and an attorney asks your client about something that they produce and they don't know what they're talking about, or they're not aware of it because they weren't paying attention. And so a lot of time and detail goes into it. We have a very serious conversation from the beginning to explain that, look, discovery is tedious. Discovery can be very overwhelming, but what you don't want to do is procrastinate. You don't want to have kind of decision paralysis and put your head in the sand. work with me. I will set up a separate meeting with my clients, if necessary, to go over each and every question to make sure that they understand what's being asked and how we should properly answer the question to best fit our needs.
And sometimes it's not appropriate to answer the question, right? I mean, sometimes they might
Exactly.
ask a question that's not worded right or asking for something
Mhm.
that's inappropriate. Tell me a little bit about objecting to those.
Absolutely. I typically, to help my clients not to cause any type of of frustration on their part, I will go through the discovery before I even give it to them and already put in my objections. A lot of times, when people aren't specific enough, they will ask extremely broad or overreaching questions that just aren't realistic. It's almost as if it's a fishing expedition because they really don't know what they're asking. And while there is some concept of document production, you don't necessarily know what you don't know, it shows to be directed. So I have objections saying that things are overly broad. If they're asking, for example, a question would be, provide all documents between you and opposing party, all text messages. What's all? You guys have been married for 20 years. What does that even mean? No, I need you to be more specific. Or they're asking for, every pay stub from every job you've had in the last 10 years. And for whatever reason, my clients had 15 jobs. It's burdensome for them to have to produce those documents. Or quite frankly, sometimes they'll ask questions that just aren't relevant. Maryland is a no-fault divorce state, and they start asking a whole bunch of questions that pertain to fault. We'll object because really there's no basis in it. Or let's say the case is about, a child support modification. You're asking about property. That has nothing to do with the case, and we're going to object.
Right.
We have to explain to our clients to make sure they understand that because discovery is about information, sometimes what they deem as private is not always objectionable. But certainly when we're talking about HIPAA or certain privacy aspects, we certainly can object. And if the attorney feels as though it's necessary, we can go before the court and have a discovery conference for the court to determine whether or not our objection is reasonable. But usually that's rare. Sometimes the other attorney is just kind of pressing our buttons to see what we're going to produce. And we just have to, advocate for our clients to let them know this isn't appropriate, this isn't necessary, and they're going to have to find this information another way or not at all.
Awesome. So obviously, sometimes you mentioned that clients don't really want to answer the discovery. They think it's burdensome, or they think it's just an exercise that they have to do. They don't want to go and get all of their documents. They don't want to. I mean, it is tough to go and pull all of your bank statements and pull all of your pay stubs. And so people often get frustrated with that. Tell us what you tell clients about the importance of discovery and why it is important to get those documents produced, those questions answered, and how it ultimately affects the trial.
Yeah, I mean, it allows both sides to properly prepare and narrow the issues that we have. Sometimes with discovery alone, we're able to stipulate the facts, which will generally shorten the process of the divorce or the custody matter. We don't have to present that evidence anymore. But also because the court and the way discovery is viewed is that both parties have a right to it in order to be properly prepared for court. And because of that, when discovery is not produced, there are some pretty serious sanctions that can come to a party and if they're not able to or they refuse to produce discovery. In Maryland, if you file for what's called a motion to compel, where you're asking for the other party to compel discovery, if they don't follow an order to compel, there could be sanctions as serious as not being able to present your case or any evidence that you didn't provide in discovery, or not being able to defend your case in regards to anything that's presented by opposing parties. So it really can handicap you if you're not producing the necessary discovery. I explained that discovery is an aspect of understanding the case, so everything that's produced doesn't mean it's going to be produced to the court, but certainly allows us to have a better understanding what the case is. But primarily, I find that explaining to them that by not producing discovery, it can lead to you not being able to present your case. That seems to be a very encouraging fact for them to actually, do the work that's necessary for their case.
Yeah, discovery is extremely important. It's the basis of the whole case. It's how we put everything together. It's how we present it to the judge. It's how we get enough information to work on settling the case or negotiating specific issues. And it ultimately, even though it is costly to do, it ultimately shortens the term of the trial or the actual divorce process, and it makes it cheaper Usually by settling it or resolving things versus having to have a full-blown trial.
I agree. Some of my best cases that were settled was because we had a very extensive discovery process. And once everyone learned what was at stake and what we had, we realized it was far better to just settle the case.
Great. All right. Well, thank you so much. Ashley, that was some great information, super helpful for anybody going through a family law matter. Again, and if you want to schedule a consultation, call 1-866-DADS-LAW or visit us at cordellandcordell.com. And thanks for joining the Men's Divorce Podcast.